we could have done that yesterday. I expected a more substantial motion with case law and additional principles of law that the court would probably need to recess and consider, but we are where we are. Having considered this case for 4 days and listened to the motions of counsel.
Right away, the judge is setting the stage for something bigger than a simple guilty or not guilty discussion. This isn't about who the jury believes yet. It's about who even gets to make the decision. Think of it as a legal system deciding which lane the case belongs in before anyone starts racing down the road.
And the division of labor in a criminal jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence, such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese, but breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury, the jury would decide the facts, which is what happened. To give an analogy, because this case doesn't put itself well to analogy, somebody is given a ticket for speeding, 70 and a 65.
That speeding ticket example may sound simple, but it's doing a lot of work here. Judges often use analogies when legal concepts get dense. Question for you. Before hearing this explanation, would you have assumed the jury decides everything in a trial? A lot of people do.
But they're stopped in a parking lot. The jury decides the question of fact. Was that driver actually going 70? The judge would decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of fact being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness. And judges resolve the questions of law. And what would be put to the jury in this case was whether or not Evony Parker is guilty. And that would be the question of fact. I do all this, say all this, because the distinction between law and fact can become convoluted, and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line, but identifying that line is important, critically important, whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge.
Now the temperature in the room just changed. Did you catch that? The judge says there is no direct precedent for this kind of case. In legal terms, that's like opening a map and realizing the road you're looking for isn't printed on it.
I guess for purposes of the party's understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application of precedent, which I would say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, January 6, 2023.
And here comes the major reveal. The judge isn't saying the events weren't serious or tragic. The question is narrower and extremely important. Did existing Virginia law actually define this conduct as a crime? Courts interpret laws. They don't rewrite them.
At Richneck Elementary School in Newport News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling. With that being said, if it's not a crime under the common law, nor under the code of Virginia, should the legislature wish to make this a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used, and unless a literal interpretation of the language will result in manifest absurdity. So now I look at the statute. Virginia Code 18.2, 371.1. What the indictment charges here is under paragraph B of that statute. It reads, any parent, guardian, or other person responsible for the care of a child under the age of 18 whose willful act or omission in the care of such child was so gross, wanton, and culpable as to show reckless disregard for human life is guilty of a Class 6 felony. The indictments in this case don't address specific individuals, but they list students. The court finds that what has been presented to it is a mashup of legal theory, and it is not clear, based upon the plain meaning of the statute, that these facts are crimes. In the court's analysis, the court is asking, is the crime that Evony Parker didn't follow Newport News policy and procedure, of which was put into evidence, which would have required two people to search the person of JT, either two administrators or one administrator and one security officer, of which the security officer was on site at a different school performing their duties, and the principal, the other administrator present, that's known in this proceeding, was in scheduled meetings during testing. Is the crime that Dr. Parker didn't direct a search of the child's person after being informed that the book bag was clear? Are the 8 counts of the indictment based upon the number of children in the room when the firearm went off? Are the 8 counts of the indictment based upon unfired bullets remaining in the firearm?
Listen to the pattern here. The judge keeps asking question after question, almost like pulling apart tangled wires. That's intentional. The court is signaling. Tell me exactly what criminal act fits this statute. If the answer isn't clear, the prosecution has a problem.
Which would be contrary to established case law, as they have to be discharged. Is the delayed reunification the reckless disregard for human life? Is it the emotional trauma of the exposed child who was in the classroom? I believe the initials were KS.
And there it is, 8 felony counts dismissed. But here's the twist that often surprises viewers. A courtroom ruling can effectively say, this is awful, while also saying this specific law doesn't apply. That's where legal judgment and emotional reaction can collide. What do you think? Should courts strictly follow existing laws, or should judges have more room when dealing with unusual cases?
Is that the reckless disregard for human life? Is it the fearfulness, bedwetting, and hypervigilance of all the children in the school that day that comprises the reckless disregard for human life? Is it because JT wasn't expelled prior to January 6, 2023 due to his previous behaviors, which presumably would be in the province of the prior principals, Dr. Goodman and then Ms. Foster? Or is the crime the lack of heightened response from Evony Parker due to her awareness of prior issues with JT? The court is unclear. And as previously stated, those legal theories do not fit the plain meaning of the statute. If they are to amount to a crime, then the legislature will need to codify it. Therefore, I do grant defense motion to strike in whole on all counts, all 8 counts of felony child abuse and endangerment under indictment CR, the indictment number 24999-541-01-08. So those matters are dismissed. I want to add, my ruling today is based upon legal principles only. It is inappropriate for me to give my personal thoughts or express sympathy or concern, but it's understanding what happened that day was awful. That was agreed upon by all. The criminal matter before me does not call for me to discuss the Newport News school system or make political observations, and I will not comment on optics or engage in speculation. For the media, who has contacted this court constantly over the past 2 weeks, there will be no further comment from this court, except to commend the attorneys on both sides, Mr. Jenkins, Mr. Rogers, and Mr. Teague, for zealously advocating their respective positions and treating this forum with the utmost decorum. It is 9:46, and I did not have the jurors reporting until 10. So I'll ask the parties how they wish for me to discharge the jurors, if they want me to just tell them when they report to the room or have them brought out and do it on the record. But in discharging them, I will remind them that no one from this court will contact them and direct them about this case. And I will ask the attorneys to please inform all of the witnesses that were to remain constructively sequestered that they are released. So from the attorneys, how would you like me to inform the jurors who are still coming in the building that they're discharged from their duties for this case?
Your Honor, I feel like we should discharge them on the record, but I would have no objection at all if the defendant or other parties wanted to leave and just do that with counsel.
Just counsel only?
That would be fine.
Okay, defense position?
Your Honor, I'm actually okay with the Commonwealth's position.
Okay. So I will step off the bench, so we'll be in recess, and then we'll discharge the jurors on the record once they all report. And to parties, please be quiet, and however you feel about the court's ruling, you can express that outside of the courtroom. This is still a professional legal forum. All right. Thank you very much. And Sheriff, come get me when they're all reported. Thank you.
Please rise. Thank you. Court stands in recess.